don't know what I'm doing, but
in the matter, my name is Nora. Appearing together with my colleagues, Mr. J.B. Ogiti and Mr. Johnson Kogi.
Be leading the pack. Mr. Langat. Thank you. Mr. Kitton.
Present, Your Honor. Keaton is K-E-A-T-O-N. Thank you.
Is present. Mr. Kinyajui.
Your Honor, Stanley Kinyanji present.
Mr. Odoto.
Odoto Kongani, Your Honor, I'm present.
And the Trojidarian Mr. Cliff Ombete.
Your Honor, good morning. I'm present.
All right.
I would like to address the two issues raised by my learned colleague, Mr. Omari. Number one is on the procedure, whether or not the PO should be subsumed in our application. We have the view that that PO should be dispensed with first, because we believe it is not a PO in the first place. It is a matter we can address in 2 minutes. So we'll give them the chance to just go through the PO. We will respond, let the court deal with the PO. Then we come to our application. We have the fear that if we subsume it, a PO that does not exist will have legs or may have legs in our application. We are not ready to give it legs. On the second issue, we would appreciate if the defense would indicate which specific paragraphs of the affidavit they intend to cross-examine the deponent, who is on my left, the second person on my left. Which we have gained sight of has not properly been served on us, but that's not an issue. We will be ready to deal with it.
It has not been filed.
Already indicated, our application is dated 16th of June, 2025, the year of the Lord. The substantive prayer sought is prayer B on the face of the application. And that prayer is that the respondent before court be remanded at the Langata police station or any other police station within the Republic of Kenya and Your Honor, the reason being, and this is a justification, that it will enable the applicant herein, the Republic, through the Independent Policing Oversight Authority, to continue and conclude investigations in respect of the facts, the basis of the arrest of the respondent. Your Honor, our application is based on both law and facts. And to be more specific, Articles 24, 29, 49, of the Constitution and Section 36, capital A, of the Criminal Procedure Code. We will also make references to the decision of the High Court of Kenya at Nakuru, Honorable Justice Joel Ngugi, a judge I hold so highly, in the decision of Sudi Oscar Kipchumba versus Republic, and this is Criminal Revision number 208 of 2020. You know, fundamentally, that decision of the learned Justice Ngugi, as he then was, because he now sits at the Court of Appeal, cites and makes reference to the decision of the High Court of Kenya at Milimani, delivered 4 years before it by the learned Justice Luka Kimaru, as he then was as well, because he equally sits at the Court of Appeal, in Michael Rotich versus Republic. And we preempt that the defense are likely to run away with Michael Rotich, so we are going to hit hard on it before they get the chance. You know, in summary, what we are requesting this court to do is to issue an order for what the Constitution calls detention continuing. So that the respondent remains in custody, that's the common name that we call it, custodial orders, for purposes of completion of investigations. You know, cognizant of the limited jurisdiction of this court under Section 8, subsection 2 of the Magistrates Court Act 2015, our references to Article 29 is only in passing and for purposes of laying basis. That every person, I am paraphrasing, every person has the right to freedom and security of their person, including the respondent. Your Honor, in further laying of the basis, that Article 24 of the Constitution allows for limitation of rights under the Constitution, save for the rights under Article 25 thereof. So that while we acknowledge that the respondent has a right to freedom, right to security of his person, and a right to liberty, all those rights fall outside Article 25 and can be reasonably limited. Where there is justification. And where, Your Honor, it is established that the kind of limitation we are seeking in the nature of detention continuing is the least restrictive measure. So that, Your Honor, once we have established, as we have, that Article 24 permits the limitation of the right to freedom and liberty, then we shall, through my learned senior, take the court through our affidavit to establish the justification. But, Your Honor, Article 49(1)(f)(1) sorry, that is 49(1)G, Your Honor, I'm sorry. And if you allow me to read, an arrested person has the right at the first court appearance to be charged or, and this is important to us, informed of the reason for the detention continuing or to be released. And so out of the three available options under Article 49(1)G, we have come to court to seek detention continuing. Your Honor, with that legal basis, allow me to make a reference to the learned Joel Ngugi J, as he then was, in Sudi Oscar Kipchumba,
Deal with the right of making submissions after we have made our submission, so that once they have done this, they will surrender. What does it say? And they'll have no right. Procedurally, it is the deponent to be put on the dock. And the deponent is cross-examined, the respondent's lawyers submit, then the state submit. But now it's the reverse. That's what I'm asking. Is my own JV abdicating wrong?
I invite my learned senior, Mr. Jalson Makori, to take you through the factual matrix in the affidavit. I am most obliged unless there's a question for me.
Your Honor, we are referring to the affidavit by one Abdurrahman Jibri. Abdurrahman of motion dated the 16th of June 2025. Your Honor, I will only take you, I will only highlight the paragraphs that are in the affidavit, which reveals in paragraph 6A to E, 6A to E, that is on the 4th of June 2025, the DCI received a complaint from the DIG of police, Mr. Eliud Langat, alleging he suffered continued false and malicious publications on an X account, formerly Twitter, with the username Pixel Pioneer, and requested investigations with a view to establish the person and motive behind it. Your Honor, A to E establishes the grounds in which the investigations were mounted. It is at paragraph 6D. On the 7th of June, the DCI team went to Linda Center in Homa Bay County and arrested the deceased at around 2:30 p.m. And they took him to Mawengo Police Station, placed him in custody with the OB number 10-7/7/6, 2025.
Read it again, 10-7-6.
That is 10/7/6, 2025. Then at around 3:54 p.m., the deceased was booked out under OB number 11/7/6, 2025, and escorted to Nairobi, where he was booked at Central Police Station under OB 136/7/6/2025 at 9:32 p.m. Your Honor, we have annexed to paragraph 6E the OB extract, that is AJ1, indicating the time that the deceased was booked at Central Police Station. Paragraph 7, Your Honor, the respondent was arrested. And this is something that would wish the court to take notice. The respondent was arrested on the 13th June 2025 at 18:05 hours, that is 6:05, which was on a Friday. The respondent in paragraph 8 was informed of the reasons of the arrest and for which and the reasons and of the offense that is being investigated. That is under paragraph 8. Your Honor, in paragraph 10, now we are coming to the reasons why we want to continue holding the respondent. The respondent is the custodian of the station records, being an OCS, officer commanding station, and the surveillance system, the CCTV. And this is at the material time under the investigations. A few paragraphs which I wanted the court to take note of. Because, yes. Yes. The defense, yes. Yes. No, Your Honor, I'm only highlighting some paragraphs. I'm not going through the whole affidavit because they have already indicated that they want the deponent on the dock for cross-examination. Yes. Your Honor, what we are... Yes, the CCT, yes. We said paragraph 10, the respondent is the custodian of the station records and the surveillance system, that is the CCTV, that is under investigation. Yes, investigations reveal that under paragraph 11, that the respondent, together with others who are not before court, hired a technician to interfere with the CCTV system at the Central Police Station in a bid to tamper and interfere with the subsequent investigations. Your Honor, we are highlighting what so far we have done insofar as investigations are undergoing. So there is still some investigations which we need, and that is the reason why we are asking for continuing detainment of the respondent, because the respondent's mobile phone has been detained. And it is subject to investigations. Your Honor, there are also witnesses who are yet to be investigated and statements taken from them. Also witnesses, police officers who are on duty at Central Police Station on that night. Your Honor, given that the respondent is the OCS, we are saying that there is a likelihood that he may interfere with the investigations. Your Honor, we'll be seeking the 21 days.
I had forgotten to hit on that issue about be allowed warrants to access their phone. You've mentioned it, but please state it. In addition to the 21 days, we're also seeking an order to access the phones.
To continue holding the respondent, and in addition to the 21 days, Your Honor, we'll be seeking an order that we access the phones
Number 18. 17 and 18.
of potential witnesses, the police officers who are on duty, and any other person who was at the vicinity at Central Police Station. And this, Your Honor, we are relying upon paragraph 17 and 18, where we have shown in the paragraphs, we have demonstrated that there is already interference, which has already been done. With that, Your Honor, we will be inviting the deponent, the doc.
I swear by the name of the Almighty God, that the evidence I shall give before this court, touching the matter in question, shall be the truth, the whole truth, and nothing but the truth. So help me God. Your Honor, I am Abdurrahman Jibril. Jibril for you, Jibril. I'm a Senior Assistant Director, Investigations with the Independent Policy and Oversight Authority.
Yes, upon this affidavit and before court.
Yes, Your Honor.
Yes, kindly proceed with the affidavit. There will be questions from the defense.
Thank you, Your Honor. Your Honor, I am one of the investigating officers in the ongoing investigations that IPOA is currently conducting in regards to the brutal murder of Albert Ojwang. This is pursuant to Section 6, 7, and 25 of the IPOA Act. Your Honor, on 8th day of June 2025, IPOA learned the death of Albert Ojwang while in police custody at Central Police Station within Nairobi County. Your Honor, the authority immediately initiated investigations to unravel the circumstances surrounding the gruesome death of the deceased. Your Honor, so far, our preliminary investigations have revealed that the deceased was arrested following a complaint by the Deputy Inspector General of Police.
Your Honor, all that the witness is saying has been said. He can only adopt the new proceeding. Because unless there's any other crucial information, he has to
That's another, Your Honor. That's okay. Okay. Yes.
Yes. Brief. Free. Me, what? Shanghai. Yes, we'll cross-examine him. The others will submit. Thank you. Mr. Jibril,
Yes, Your Honor.
can you confirm your position at IPOA over this matter?
You are asking my rank? My
Yes.
investigations.
And confirm that you are an investigator.
Yes, Your Honor.
Are you an investigator in the purpose and the name or position of the National Police Act?
IPO Act.
Under IPOA Act. And under IPOA Act, is it true that you have still arrested powers?
Yes.
Under which section?
Your Honor, Section 7 of the IPO Act and Section 7 of the IPO Regulation Act actually gives me the powers, privileges, and immunities of a police officer.
So Section 7. And which section?
Both Section 7 in the IPO Act and Section 7 of the IPO Regulations Act.
Gives you the powers as that of a police officer.
Yes, sir.
And in this matter, you are now actively participating pursuant to those provisions as an investigator.
Yes, Your Honor.
Thank you. Are you well conversant with the law?
Depends on which area you want to ask.
Are you, you know, some of us went to teach, then we became lawyers. Some people are mad about that. Do you have any legal training?
Yes, yes, I do.
Could you refer the court to your legal training?
I'm an advocate of the High Court of Kenya.
Thank you. You are an advocate of the High Court. Look at the Criminal Procedure Code, Section 386, as an advocate of the High Court of Kenya. Could you be given it?
Your Honor, we'll have an objection.
I've not asked the question.
We can see. Your Honor,
I've not asked your question.
Your Honor, at least should I be allowed to make the objection?
Of what?
Let me just object, then you
No,
can...
no, no, no. You wait until I ask. I'm just told to look at it. It might be just to admire it. Allow me to ask.
Your Honor, we'll be requesting the court to just... Yes.
Okay.
That's right. Your Honor, the witness before the dock has come here on the basis of his affidavit on the factual matters. And that explains why the defense requested that my colleague, my learned senior, does not go into the facts. Section 386 of the Criminal Procedure Code, or whatever provision of the law, is a matter of law. And Your Honor, the objection again goes into the earlier intended preliminary objection, which we have had sight of, where the argument, in a sense, is that this matter, now we have had a copy, although it's not filed, this matter should have been the subject of an inquest and not a miscellaneous application. So that because we are alert, the defense should not try through the window to bring in a preliminary objection which they admitted not to have filed. But more importantly, that this is a witness of facts, not a witness of the law. We can deal with the law between the lawyers. Thank you.
The late.
Central Police Station cells, Your Honor.
Central Police Station cells. From the IPOA Act, provide there's the mandate for you to investigate somebody dead in a police cell.
Yes, Your Honor.
Read, show the court. Because you have confirmed he is the scene of death is at the police cell. Which mandate gives you that power? Let him answer.
When we are still objecting, counsel is still taking the same route.
I've said under which mandate they are coming before this court.
To just remain respectful. We know that they are very good people. Let us.
Paragraph 3.
That investigations by IPOA are pursuant to Section 6A, 7.1, and 25.1 of the IPOA Act.
Is that the law?
Yes.
Is that a fact or that is the law?
That is a fact as per this affidavit.
That's what I'm saying.
Yes.
You have quoted the law. True.
Yes.
Therefore, it is not wrong to ask you a question of law because it is you as in your affidavit talked the law. Give me the law that gives you mandate to investigate a person who dies in a police cell. That is simple.
I have indicated the sections 6.1, 7.1,
Tell
and
the court.
25.
Just
Yes.
tell the court.
Your Honor, I have indicated section 6A, 7.1, and 25.1 of the IPOA Act.
Could you kindly read to the court those sections that gives you that mandate? The IPOA Act. Just read to the court those sections for the benefit of the whole world. We don't work for IPOA.
Neither do we.
Your Honor, because we did not anticipate that a witness of fact will be made to read the law.
6A, you read.
Okay. Section 6, Your Honor talks about functions of the authority.
Yes.
Here means IPOA. That the functions of the authority shall be 6A, investigate any complaints related to disciplinary or criminal offenses committed by any member of the service, whether on its own motion or on receipt of a complaint, and make recommendations to the relevant authorities, including recommendations for prosecution, compensation, internal disciplinary action, or any other appropriate relief, and shall make public the response received to these recommendations. Shall I continue?
Yeah, anywhere where. JV allowed the witness to read.
Sorry, Your Honor.
Before you even say that, this is a question.
That's right. That's right.
And the question we are here about is specific to death inside a police cell. And that is all I'm saying. If he says that section, then the court will go and make a ruling out of it. That's all we're asking. In relation to death in a police cell.
In police custody.
It's not you to set my question. I've asked you my question. You can't set a question and answer yourself.
Yes.
If it's not there, it's not there.
We have powers to investigate death that occurs under police custody. Yes, and custody includes
The
cells.
court has quoted what we have asked. The question has been answered. We'll do submissions on it. That's all. Let's go to paragraph. You have paragraph 7?
Yes.
Read to the court what that paragraph says.
Your Honor, the paragraph says that the respondent was arrested on 13th June 2025 by DCI officers and subsequently handed over to IPOA and was later booked at Langata Police Station via OB 50-13-6 of 25 at 18:05 hours.
The DCI officers arrested him at what time, according to your?
He said around 3.
You read exactly what you're saying.
I've not indicated the time.
That's what I'm asking.
Yes.
It is not indicated when the DCI officers are arrested.
Yes.
Where did they arrest?
At the DCI headquarters.
And not Eldoret.
No, Your Honor.
Found that the accused was not arrested at Eldoret.
According to the officers who handed over me to Mr. Talam, the officers informed me that they arrested him at the DCI headquarters.
Thank you. I'm putting to you that IPOA released a false information to the public that he was arrested in Eldoret en route to escape to Uganda.
That is not in my affidavit.
I'm saying what is in social media is that the respondent...
Your Honor, I can only answer what is in this affidavit.
Sorry, Your Honor. Yes.
Yes.
Let's proceed on the question of arrest. Are you aware the Director of Criminal Investigation, my friend Mr. Mohammed Amin, said the respondent is a person of interest?
That is not in my affidavit.
That's why I said, are you aware? If you are not aware, you are not aware.
Counsel, please ask me what is in this affidavit. I'm not going to, Your Honor, I'm not going to answer anything outside the affidavit.
I put it to you that based on the DCI mentioning the respondent, on that day at 2 p.m., he presented himself to the DCI headquarters in the presence of his advocate, Ojwan'G. Were you aware of that?
If you said so.
Thank you. And the DCI authorized his officers together with the advocate to present the respondent to IPOA headquarters.
Your Honor, we have said time and again.
I'm putting it to you.
Please,
you don't need to answer.
Please answer me ask me what is in my affidavit. Let's stop charges, Counsel.
Counsel, I've only put it to you, I've not asked you a question.
Is it in my affidavit? The question I'm asking to you is it in my affidavit? The answer is no.
Of the court, I'm putting to you, then I'll ask you where you are saying you are arrested.
Your Honor, I will decline to answer anything which is not in my affidavit.
I've not asked. I've not asked.
Then please ask.
I put it to you that the officers handed over the respondent to IPOA in the presence of Mr. Keto. As I put it to you, for the record purposes.
Samson Talam was brought to IPOA head office by DCI officers.
And he did record a statement at IPOA in the presence of his advocate, Ojwan'G. Kiprono. Who is it?
Is that in my affidavit?
I'm putting it to you, Counsel. You are a counsel. When it's a question, I'll ask you a question.
Please,
I'm only putting to you
ask
for knowledge
me
purposes. So now, if those are the facts, look at the paragraph you said he was arrested. Paragraph 7. Now I'll ask you questions from there. Read.
I have read and read. What is the question, please?
No, cool. It's a long day.
No, it's a long day, yeah? It's okay. It's okay.
The state is rich, it can bring water.
Yes.
For both of us and council. It's a long day. Can you confirm that paragraph 7 is not true, that he was arrested by the DCI officers?
The respondent was arrested by DCI officers after he presented himself and brought to IPOA.
Do you have any evidence material to that effect? I've given you the scenario the way it was.
No. The fact that he was brought under the escort of DCI officers means he was arrested and brought to IPOA office.
The court has taken that. Let's go further.
Sorry, Your Honor, I think this may be my last objection. We hope that counsel is not proposing to court that he has an alternative set of facts which the court should take note of, because counsel is not a witness. If he wants to give us his alternative facts, we would expect an affidavit so that we also put him on a dock and cross-examine him.
9.
Yes, Your Honor.
Paragraph 9.
Yes.
You have said what about the position of the OCS?
That the respondent at the material time of the incident, he was officer commanding Central Police Station, exercising command of the Central Police Station, hence persons of influence, and has capacity to interfere with the ongoing investigations and likely witness.
Do you have any evidence to show that he was in full command at the police station at that time?
As an OCS, that is.
No, I've asked a simple question. It is either you have it or you don't have it. Do you have anything, either duty roster or something showing he was on duty
Your
or
Honor,
in command?
Your Honor, what the advocate is asking is that you are the presiding magistrate here. Do you have the power over this court? I mean, once you are an OCS, you have got a power over that station. Come on, counsel.
We have agreed that you don't have it. You are looking for anything. Let me put it further.
And
let me put it to you.
And Your Honor, just to answer also, whatever evidence that I had, I have put as an extra. Anything else which is not here is purposely done to safeguard, first of all, the integrity of the investigations. And they will be provided at the most relevant time. I'm well aware that this will not be the forum where those charges will be preferred. Yes.
And I've asked a simple question.
Yes.
Among the annexures,
There are none.
have you produced an annexure showing he was in command of the police station at the time the offense was committed?
I recorded his statement and he confirmed that at the time of the incident, he was the officer commanding station at Central Police Station in the presence of his lawyer. I have not attached in this affidavit.
Simple. The answer is clear. You have
Yes.
not attached. All that's what you are looking
Yes.
for. It's not attached there.
And maybe to answer your question, any other attachment that you might ask is not there, save for the OB extracts,
Just don't go for that. And you are a lawyer. When I say I put it to you, don't respond. I've not asked any question.
You're putting.
then
And I
why
put it-
are you putting in the first place?
Yeah.
The question is, why are you putting in the first place?
Putting all over. You can put it there.
Allow us to proceed. What is relevant, record. What is not relevant, leave it. I put it to you that the OCS left the police station and the deputy was in command as an OCS.
That is not in my affidavit.
And I put it to you that the OCS was never near Central Police Station.
That is not in my affidavit.
Thank you. The world has heard it. So let's go, paragraph 15. On the question of him likely to plan. You're there?
Yes.
We have agreed there is no any material.
Yes, nothing
Thank you.
attached.
Let's proceed.
Okay.
Paragraph 10.
You go back.
Oh, I asked you paragraph
15.
15.
Yes.
I'm going to paragraph 16, sorry.
Okay.
Still no material attacked. It's either very serious material you have kept, no material attacked.
Yes, Your Honor.
Thank you. Paragraph 17 about the CCTV.
No material attached, Your Honor.
Thank you very much. Paragraph 18,
No material attached.
no material attached. Paragraph 17,
Come on.
I've gone back because there's a question I want to ask.
Yeah, please ask.
You have said about the CCTV cameras. Do you have possession of the scene of crime as of now?
No.
Who is in possession of the scene of crime?
The scene of crime was processed and released. Remember, that's a police station. You cannot hold a station as a crime scene for a very long time. So we have released to the relevant authorities.
Is that on off? Because I was there yesterday myself. It's not true that the scene of crime has been released to the police.
Then
Is it still a scene of crime, or it is non-operational police station?
that question is not, it's not in my affidavit.
You've run very fast. Do not lie like that is. So you cannot, there's no material to show that.
Nothing attached, Your Honor.
Paragraph 19. You've read it?
Yes, Your Honor.
And 21, they are the same?
What's the question? No material attached.
There is no material attached.
Yes.
That is very, very critical to us. Paragraph 22. I still ask you this question about the blue code of silence.
I will refer you to the High Court decision.
Tell the court. This is a lawyer. He knows High Court decision.
Court of Appeal decision.
Give the court that decision.
In the Titus Ngamau case, 2020. It was a phrase coined by the judge who was dealing with that matter.
And I remind you, Cliff is the one who argued that matter.
Yes.
He'll face you over that matter.
It's okay.
He's the one who argued that matter. Cliff will deal with the blue code. Paragraph 23. You are now providing reasons as to why you want him to be detained for 21 days. True? From paragraph 21, 23.
Yes, Your Honor.
What is the reason you want to detain him in paragraph 23?
That we are yet to record critical witness statements.
Very well. Is his presence required physically when you are recording statements from other people?
His detention is required so he doesn't interfere with the witnesses.
About recording statement and interference are two things. Wakili,
I have responded to your question. The reason as to why I'm seeking that prayer is to have him detained so that he doesn't interfere with the witnesses.
Very well. Does he know the witnesses?
Them being police officers? The answer is yes.
Is there anything you have shown of any attempt to interfere with witnesses? Because, counsel, you know very well the authorities, the Sagari, Duarte Sagari, Cliff will ask you. The questions I'm asking is to prove, have you demonstrated by material your varmint?
Nothing attached.
Thank you. The court has come. Paragraph 24. What are you addressing?
That we are saying if released, his security is not guaranteed due to the public anger demonstrated by the case. I've just read what is in the affidavit.
Yes.
I'm saying that the gruesome murder of the deceased has illustrated widespread public anger. And therefore, if released at this point, the respondent's security cannot be guaranteed.
Mr. Whitty took us a lot about the case of Oscar Sudi. Heavily. Have you ever had a chance to read paragraph 32 of that decision of Professor Justice Joel Ngugi?
Not in my affidavit.
It's not in your affidavit.
Yes.
For the benefit of doubt, you are saying you want to detain him on two limbs. One, for the safety of his life. True?
Yes.
Do you have anything to show that his life is in danger?
Nothing attached.
Do you have anything to show that he is a danger to anybody of the public?
Nothing attached.
So it is an apprehension.
Yes, Your Honor.
Thank you. It is an apprehension. Lawyers swear to be court officers. It is an apprehension. And you are very aware that the National Police Service is the one mandated to provide security for everybody in this country, including the already convicted murderers. You're aware of that?
Not aware of it.
No. You will feign to be not understanding what I'm asking. I'm asking you this question. The duty to protect life and property falls under the police.
If you say so.
And this country is not a banana country where the rule of law has broken. So it is not right to say you are preserving his life in cell and he pays taxes. Everybody pays taxes to be protected. And that it will be dealt with in the cases that I've talked about. Now, what other reason do you need him in cell to detain him for 21 days?
All I stated
what
in my
do
affidavit.
you specifically want him to do?
All I have stated in my affidavit.
Is there any other reason we have not dealt with?
Everything I require, I have indicated in my affidavit.
Confirm you have his phones.
His phone.
His phone, you have it.
Yes.
And you are seeking this court. Did you have the court order to possess that phone?
I don't need a court order to possess a phone.
Do you need a court order to get access to the phone?
Yes, I do.
Where is the provision that does not allow you to have authority to possess?
It's a seizure.
Surely.
Wait,
Sorry, no. Yona, where is the provision that does not allow you? Surely.
Where is
You
the
are asking
provision?
for a provision which does not allow you. This is a negative provision, does not exist in our law. He should tell us the positive provision, and council can put it. He can continue putting it to him that this provision does not allow you, not the negative provision.
I'm rephrasing. You know, which has a problem is preparing for the judge. It's not akin to this matter. You need him 21 days for the sole purpose of granting access. Is it him who grants access or the court?
No, Your Honor.
Who grants?
I need the 21 days to complete my investigations.
I've asked a question specific. Do you need my client in cells for the purpose of analyzing the phone?
I need your client in custody for 21 days to complete my investigations.
I've asked a simple question. Is there any role he's required to do in forensic analysis of our phone?
I'm not an expert in forensic analysis, so I cannot say.
So, your varmints are not based on any scientific, because you never consulted a forensic expert? It is you swearing 21 days.
Yes.
And I've asked you, should the court, why 21 days? Why do you need him specifically?
Your Honor, the issue is not about only phone extraction. It's not only about phone analysis.
What else?
I have said to complete my entire investigations that entail so many things. Among them, what you have stated.
And lastly, you have already attached the order in your application. Look at it. We have an order. True? Makori, this is
Mr. Jibril, I want you to confirm to the Honorable Court that indeed one person of interest in the matter surrounding the death of the late Albert Ojwang is the Deputy DIG Edwin Lagat.
Please repeat the question.
I want you to confirm to the Honorable Court that the late Albert Ojwang was arrested pursuant to a complaint made by the DIG, Mr. Eliud Lagat?
Yes, Your Honor.
Thank you. You also want to confirm to the court that from your preliminary investigations, the late Albert Ojwang was arrested and put in police cell, largely due to the complaint that was made by Mr. Eliud Lagat. Is that correct?
Yes, Your Honor.
Thank you. You confirm to the court that the investigations you seek time to continue with are investigations meant to assist you to unravel the persons who should be held culpable for the death of Albert Ojwang. Is that correct?
Yes, Your Honor.
Thank you. Please inform Your Honor the name of the chairperson of the body where you are coming from.
Your Honor, I think we have agreed that what I'm going to answer is what is in my avowment.
Please, just listen.
No.
This is cross-examination.
I decline to answer that question, Your Honor. It is in public domain who is the head of IPOA.
Just respond. That is your work here.
I'm responding.
Please respond. Who is the chairperson of IPOA? That is your work.
My response is it is not in my affidavit.
Yes, yes. JV just inform me.
No. Your Honor, we have agreed that I will be cross-examined on what is in this avowment. The chairman of Independent Policing Oversight Authority's name or his position is not in my affidavit. Yes. Yes. And the council knows who is the chair of the IPOA.
I don't know. Please answer the question. Who is the head of the body where you hail from?
We don't have a head. IPOA does not have a head.
So who is the chair of the IPOA?
Yes, that will be a right question. The chair of IPOA is one Ahmed Hassan Isaac.
Thank you. Thank you. Now, you confirm to Your Honor that there was a joint press conference on the 9th day of June 2025. Is that correct?
Your Honor,
No,
I'm not going to answer anything outside my affidavit.
Your Honor, if you permit me, just to also give context why I am asking this question. Your Honor, my learned senior and friend, Mr. in explaining the authority that was made by my Lord Professor Joel Ngugi in the Oscar Sudi case, some of the parameters that were set by the Honorable Court were two. I think that is paragraph 24 of that authority. On the question about bad faith, the question about exceptional circumstances, and lastly, the balance of the quadruple rights that the court should look at. One of the items that we have a duty and responsibility to prove to you is to demonstrate to you that indeed there is an element of bad faith in the application that has been made before you. And that is why my questions are aimed at eliciting some of these facts based on the evidence that is going to present before you. So, Your Honor, I plead with humility that counsel, my colleague, I even suppose he's my senior. My senior should just
No, I'm not
be
your senior.
kind enough to
I'm not your
respond.
senior.
Yes, looks are deceitful, but
Your Honor, yes. Let me say this. Let me say this for the record. No, let me say it for the record. And Your Honor, protect me. The counsel who is on the floor asking questions should only answer. Learned senior should stop pointing at me. You will have your time to ask me questions if you require. The second, Your Honor, the second point I'm making here is that anything outside this affidavit, whether our chair is not within my knowledge, and please stop asking me. Anything outside this, I'm not ready to answer. It's not within my knowledge, and believe. And after all, Your Honor, the application we are making is about an extension of continued detention of the suspect. It's not about what happened on the backyard. What you are pointing is bad faith. Yes.
counsel, please confirm to Your Honor that there was a joint press conference on the 9th day of June 2025 where the chairperson of IPOA was in the company of Mr. DIG Eliud Lagat and the Inspector General of Police and others.
I'm not aware.
You are not aware. Thank you. have not, Your Honor, you have no information that indeed your chairperson held a joint press conference with one of the persons who's been constantly mentioned in the death of the late Albert Ojwang. You have no information, isn't it?
Your Honor, the chair attends several press conferences.
Leave those several.
So I don't follow the chair.
Thank you.
I don't follow the chair for his press conferences.
Thank you. Now, Your Honor, that is very important. You have been very honest with the court. Now, I want to return to paragraph 27 of your affidavit. Yes, paragraph 27. You have made mention that the reason why you are inviting the court to order the pre-charge detention of the suspect before court is because you have fear that he might run away from the jurisdiction of this court, isn't it?
Yes.
Have you, in your well-elaborate affidavit, demonstrated an instance where probably he was invited, he never turned up, or you have proof that he has already booked a ticket to a certain foreign land that you have presented before court?
That is not in my affidavit.
No, you have in your affidavit. Yes or no?
Yes.
I am asking you again. In lieu of your paragraph 27, on the question about the temptation by the suspect to run away from the jurisdiction of this court, if allowed his liberty, have you provided before this court
No.
any material?
No.
You don't have any material?
No.
Thank you. Your Honor, that should be all from me. Thank you.
Then I can do 1.5 minutes, depending on how it's going to answer. Now, Mr. Jibril, I want you to remember the testimony that you've given us just a few minutes ago, where you told us that the scene of crime was processed and released to the relevant authorities. Is that still your stand?
No, it's not in my affidavit. That's my
I'm
answer.
asking you,
Yes.
you made a representation to this court and told us that the scene of crime was processed and released to the relevant authorities. Is that correct or not correct?
Now, Your Honor, the scene of crime here I'm talking about.
Is it correct or not correct?
The cells where the deceased died has been processed and released to the relevant authorities.
Thank you. Now, can you tell us the investigative steps that you have used to preserve the CCTV and the occurrence book? Right now?
No, it cannot be.
It cannot be.
It cannot be in my possession.
Have you extracted the relevant entries on that particular day?
Yes, and attached to the affidavit.
Thank you. Now, number 2, about the CCTV, can you tell us the preservation measures that you've taken to preserve the sanctity of that CCTV footage?
Your Honor, we are a team of investigators. That aspect is being done by the forensic team.
So you can also confirm that the CCTV in itself is not with the police station. It is with the forensic team.
And what was extracted is the only DVR. But the entire, you can't carry a whole screen.
It's okay. That's what I want you to tell me.
Yes. What was extracted is only the DVR.
Yes.
Yes.
So the DVR that records the events of that fateful day is the forensics team.
Yes.
Thank you. That's all you
Where you have said that you received a complaint from the Deputy Inspector General of Police. Confirm?
Yes, Your Honor.
Under the Langata Prosecution Office number 50.
Yes. Yes, Your Honor.
Who booked the respondent at Langata Police Station?
The booking was done by myself.
It was done by yourself?
Yes.
Thank you. Are you aware of the law governing the booking of a person at the police station?
As per the IPOA Act, yes.
As per the IPOA Act?
Yes. And the regulations.
For instance, are you a police officer or a former police officer?
I'm not a police officer. I'm an
Have
IPOA
you been
employee.
a police officer?
Yes, I've been a police officer.
You have been a police officer?
Yes, Your Honor.
Thank you so much. Paragraph 21.
21, yes.
Do you know the co-conspirators by name?
That is part of investigations. I cannot reveal here.
No, I'm just saying, do you know by name, not their names. Do you know them by name?
You don't have to need to name them.
Counsel, this is what I've been saying.
Relax, Jibril.
Let me answer her. The thing is,
Let me help you.
yes.
Just say yes or no. Do you know the co-conspirators?
The matter is under investigations.
Yes or no?
As of now, no.
You don't know them. Thank you so much. Number 27. You have said that there was the murder of the deceased was planned, executed, and their attempts to cover up. Do you know the people who are trying to cover up the death of the deceased?
One of them is your client.
Do you know that with certainty?
Yes.
Have you provided evidence to that effect? Or
No.
the attempt to cover up?
It's under investigation, but not attached to this affidavit.
You have said that, yes, you know the client is one of the people trying to cover up. My question is, have you provided evidence that he is one of the people who is trying to cover
As of
up?
now, no.
No.
Yes.
Thank you so much. Thank you, Honor. That is it.
I think, Your Honor, that will
I will limit my questions back to the contents of your affidavit, many times by paraphrasing.
Okay.
What is the basis of your request for detention continuing today in one line?
To complete my investigations.
On a scale of 0 to 100%, how much could you, by approximation, attach to your investigations up to now on a scale of 0 to 100%? Doesn't have to be accurate, approximation.
49%.
49%. So I can mathematically say this as direct evidence that you're saying there is 51% of investigations to be done.
Yes, Your Honor.
So that there are questions about who is in charge of the cells, who is in charge of who is in command of the station. Do those questions relate to the remainder of your investigations?
Yes, they do.
Now, to ask another direct question, are the questions from the defense some of the things you need to investigate to complete your investigations?
Yes, Your Honor.
Thank you very much, Your Honor. I'll hand over to you, Mr. Johnson.
Just one question in the examination. You have been asked whether you have attached any document relating to, I think it was paragraph 6A and paragraphs in your affidavit, whether you have attached anything to show that even the respondent is a flight risk. Why do you need the respondent in custody? Is there any reason why you have not attached any?
Yes, Your Honor. The reason I have not attached what I've collected so far, the 49% I'm talking about, is that it will jeopardize the investigations. And this is actually to protect the integrity of the investigations. That's why we cannot divulge much.
Thank you very much. I believe that is all from our end.
That 6A was an amendment following the locus classicus in Michael Rotich, that is in Michael Rotich versus the Republic, the 2016 decision, whereby, Your Honor, in this section, it lays the two-tier threshold for such an application to succeed. The first burden, Your Honor, is on the investigation, that is the IPOA. That 6A, it is very clear that pursuant to Article 49(1)(f) and (g) of the Constitution, a police officer shall present a person who has been arrested in court within 24 hours after being arrested. And now it lays now what the investigation officer must do. First, he must make an application in writing. First, he must produce the suspect in court, which they have done, which we admit that. Then the second thing, Your Honor, is that they must apply in writing. And they have done that through this motion application. But now, Your Honor, the greatest issue that they must also do, Your Honor, is that under section 36A clause 3D, it states that the investigation must also adduce the reasons necessitating the continued holding of the suspect in custody. So the question that begs our attention at this juncture, Your Honor, is whether there are reasons necessitating the continued detention of the respondent. And we submit, Your Honor, in negative, that the investigations have not adduced any cogent reasons necessitating continued detention of the respondent. And Your Honor, my learned friend, they have already gone through the cross-examination limb by limb in the entire affidavit. But if you may permit me only to refer you to 2 or 3 salient issues, Your Honor, in order to illuminate why this motion application is bereft of meat and substance to stand on. First, Your Honor, we submit, Your Honor, that that is not a cogent reason. And we'll invite you, Your Honor, to consider the authority which we have provided, that is Republic versus Mercy Chebet. It is a 2022 decision whereby Justice Igonyo has indicated succinctly, and I will humbly refer you, Your Honor, to paragraphs 17, 18, and 19 of that decision, whereby the High Court has settled the law that for such a threshold to succeed, the investigation must tender material information to the Honorable Court to demonstrate the nexus link that is between the respondent and the likelihood of interference. And I will also refer you, Your Honor, to also adopt the reasoning of Justice Mutuku in Republic versus William Chichiri and Godfrey Kirui, whereby the same threshold.
Your Honor, this is not an objection. It's an humble plea.
Justice Igonyo has laid the threshold and also illuminated that interference with witness undermines the criminal justice system and dents the integrity of the criminal process. And he goes on and also says that for such a ground to succeed, the prosecution must tender or must present material information to the Honorable Court. And the other decision which we have also cited, Your Honor, the William Chichiri case, whereby Justice also Mutuku has said that there should be a nexus between the respondent and also the stated interference, Your Honor. So that was the main ground, Your Honor, that has been advanced at paragraphs 9, 10, 11, and 20 of the affidavit. Another leap, Your Honor, of the affidavit whereby you have been told, Your Honor, that the gruesome murder of the deceased has elicited widespread public anger and outrage leading to demonstrations, which at times have been destructive. Hence, the safety and security of the respondent cannot be at this point be guaranteed if released on bail. So in order, Your Honor, to demonstrate that such a reason, Your Honor, should not hold waters is that we will humbly beg to refer you to the same decision of Justice Igonyo, that is Republic versus Mercy Chebet, whereby at paragraph 20, which is also titled Safety and Security of the Accused Person, the judge lamented, Your Honor, at paragraph 21, that I have lamented time without number, and again, slide into brief. How and why in this age and time should people take the law into their hands to harm the accused? The community herein is within the territorial jurisdiction of the Republic.
That we have no objection to proceed.
want to examine the gadget, given the fact that they already seized and in custody of the gadgets, as to whether we oppose or not, we would not control what we do. Principally, what Your Honor is being called upon is to give a continuation detention of 21 days to complete investigations. We submit, Your Honor, that the position of my good friend, Mr. Jibril, that he has since the last 7 days covered 49% of the would-be investigations. I doubt that he would need 21 days to complete the remainder of the 51%. Why am I saying this? The frustration of my good colleagues that, Your Honor, be minded of the provisions of Section 123 of the Criminal Procedure Code, read with Article 49(1)H, as well as G of the Constitution of Kenya in matters bail, that you be inclined to admit the respondent to a pre-plea bond condition is the positive aspect that we are all taking, and we have no doubt that Your Honor, clothed with white powers to make such a determined decision on bail bond, would grant. But in the unlikely event that Your Honor is disinclined to grant bail bond as is being prayed, that you consider that the days so requested for 21 days are days which are more than sufficient for them to rely on. We are saying that the custodial detention should not act as a punishment. Given the fact that you've been told the cooperativeness of the respondent and the clear position of the application before you, as well as the affidavit of one Mr. Jibril, which presents before you no evidence that the respondent is a flight risk, no material evidence, as said, is placed before you that the respondent is likely to interfere with any witnesses or investigations as they are ongoing. But most importantly, that their wish to have the respondent not granted bail is premised on his own safety. And we would only ask, is the police saying that they are unable to secure and safeguard the safety and interest of its citizens? In the threshold of that, now we will plead, like my colleagues have pleaded, that you be inclined to grant the respondent bail bond pending this investigation.
Quiet about it. And if they want the password, we can give it here in court now, so that that point, ya kutaka simu, is out of the window. Let's finish that one. It's a simple thing, a 1 minute thing, doesn't need 21 days. They tell you that there are CCTVs that are within Central Police Station. And that the suspect, the respondent might interfere with them. But the investigating officer has told you clearly they have taken the material that was required. He called it a DBI. That is the most important one. So what they have there is a shell. And that's the reason why they can't pick it That's why the OCS here cannot pick it. So that is the second point. That issue about the CCTV, we kill it right now. They have nothing on it. Then they're telling you they are going to interfere with investigations. But in his affidavit and what he has said here on oath is that, in fact, I've given the password. Pick a password.
You read the whole one.
It is there. It is there. Just go.
We have given you the password.
Yes. They are telling you.
It's okay, you don't have to take it, eh?
Yes, the issue is not about the SIM or the password.
You know, you can't participate. Watching me. I'm running the show now. Yes. Now, Your Honor, they are telling you about witnesses. They are not telling you in the affidavit which witnesses, but they are telling you something else that is imaginary, that they are yet to get some other witnesses who they are going to record their statements. What does that show you, Your Honor? That the OCS does not have the names of those witnesses or does not know them. Does not know them. Such that if we come then to the issue of witnesses and interference with them, it is finished. One of the reasons that the court wants to grant bail to an accused person is whether he's going to appear in court or will appear where is required. Why is this important? Let us look at the antecedents of the respondent here. When the IO here called him, did he appear? Yes. When he was told to go and record a statement, did he appear? He did, and recorded a statement under inquiry. When the DCI director himself spoke, exhibited a person who's capable to cooperate and even volunteers before they get those Subarus to go and pick him. He volunteers. So today, we are talking of a person who knows the law and respects it. Those are the grounds that they had for you today, Your Honor. So what else remains? Now let us go back to that issue of the definition. Then have they convinced you, Your Honor? And I'm saying they have not. And that is why I will agree with my learned colleague that if you gave him a cash bill of 7K, that is fine. In fact, for me, I'd say free bond. Because at the time he was going to those officers, he was okay. There was no money, there was no cash bill, but he went. That shows a person willing to come to court. They quote Article 19, they quote all those articles in the law. But you see, Your Honor, today, let us agree. Why do we have these fundamental rights? It is so that we can protect this kind of person from this kind of people. The police. That is why you have these fundamental rights. And Article 19 is quite clear, and it's my favorite, that these fundamental rights, who do they belong to, Your Honor? They belong to an individual and not the state. Not the state. Once they know that those fundamental rights exist, they come to Article 20, which is very clear and says it binds all state organs, including the court, including the prosecution, and including the officers, the police officers. That includes also IPOA. If it includes them, today they come with an affidavit and tell you, deny him bond on very flimsy grounds. Did they read Article 21? I am certain that they ignored it because Mr. Whitty, my friend here, would have told them. One is clear that when these fundamental rights are known to exist, all these arms that I have mentioned, what are they supposed to do, Your Honor? They must start by wanting to grant these fundamental rights. Article 20, sub-article B. Might start by wanting to grant to ensure that this person enjoys the fundamental rights. But they still give you this affidavit. So what do we do, Your Honor? Article 22 is clear. Once we have noted that they are in a position where they want to prevent an enjoyment of these fundamental rights, we come under Article 23. And then, Your Honor, if that is the position, and then they come and tell you, oh, this, the republic order and issues like that, and that the safety of this person depends on them keeping him in custody. Ulisikia wapi? Where that? And he is my friend. Now, Your Honor, I know when the state wants to respond, they will start telling you about probabilities. They want to tell you that nowadays it's on probabilities whether a person will appear or not, that they anticipate. And you can see from their affidavit, they are alleging, they are saying likely to abscond, likely to interfere. It remains likely. Let us change that scenario of likely. Let us move from the bail bond issues first of all. Let us go to what the law says today. Law is very clear. And there are three authorities that I will give the court. One I've already given, the one of Oyamo. Then there is one of Richard David Alden versus the Republic, that is number 40-something. Oh, you see, I'm even so confused myself, Your Honor. Richard Alden versus Republic, that is in the High Court case number 48 of 2016. Yes. And then the other one is Dwight Sagarai versus the Republic. That is number 61 of 2012 before the High Court. Proudly, let me say that I appeared in the matters. What did the court say when somebody makes an allegation to do with somebody is going to interfere? The court did not say probably. The court said must put evidence, must show something, must produce something. Why? Because if we were to leave it to imagination, the sky would be the limit. So if you are saying somebody is interfering with witnesses, you must show that he directly interfered or indirectly or has attempted. In the affidavit that you have been given, nothing is there. They are saying likely. That was held by Justice Korir in the Dwight Sagarai case and was also supported by Justice Lesit as she then was in the Richard David Alden case. If you're going to say somebody is going to abscond, what does the judge say, Lesit? She says that you must be able to show that an attempt has been made by the person to try and abscond. Not only that, maybe there's a ticket, plans of traveling, or arrangements made. So I'll ask you, Your Honor, and I will give you the answer. Have they given you that? Then the answer is no. Such that even in the case of Oyamo, when they are saying that public order and public interest and all that, the court in Oyamo versus Republic, and this is a court of appeal case, and that is the law. What does it say? For you to say that there is public order and rest and all those things that they are saying, they must show. All this unrest that has been going on has not been because of the OCS. Tuesday, tomorrow, there will be an mandamano in reference to somebody else. Not him.
You know, we hope that goes on record from counsel. That matter of fact, we hope goes on record.
Your Honor, it's even on social media. And let me tell you why they can't tell me not to say anything about social media. In his affidavit, he said they got these issues from social media.
Your Honor, we admit that counsel can go to social media. We're just asking the court that as he says it from social media, please record it for us. We will use it.
Yes, Your Honor. And if that is the position that they are going to say and they are going to use it, let me tell you, Your Honor, it was not in relation to the OCS. It must be mentioned that it is the OCS and it must be accurate. Let us not generalize. That is why that law has never been overturned. Until today, it has never been overturned. So, what then does that leave the prosecution with? An empty shell, Your Honor. Today, they have come to this court not, as I said, to do this case in a proper manner, but in bad faith, which I've demonstrated, and an affidavit that does not meet the requirements of Article 49, and at least what they will come out from with here is that at least I've given them a definition of compelling reasons. Mmeelewa hiyo?
Yes. Thank you.
Let me read. Cliff can, for the prosecution, that is Owiti and my good friend Makori, to succeed, which demonstrate actual or perceived interference, it must show the court, for example, the existence of a threatening communication between the accused and witnesses, close familial relationships between my good brother. He admitted he has nothing, no material before this court. Still, Your Honor, in that case, to read the final authority holding in Panju versus Republic, 1973, East Africa Law Reports 284, where the court, in dismissing the prosecution's fear of interference with witnesses, the court stated that before anyone can say there would be interference with vital witnesses, at least some facts should be led to the court. Otherwise, will be asking the courts to speculate. I don't know whether they will consider and say, release our person out of order. Your Honor, as a human being, because we have been arguing about the OCS as an office of the court, I want to bring to the attention that the respondent joined the police, and I wish it to on record. He joined the police in 1996. At the track record is unimpeachable. Number two, Your Honor, he's a father. And on that ground, as a father, he wishes to pass condolences to the family of the deceased. As a father. As a husband, he seeks this court to take judicial notice that he has a home in Eldoret. And is ready, once the court agrees with his application for bail, not to set foot, not only in Central Police Station, but anywhere in Nairobi and the environs. He is still a police officer, though in interdiction. He understands the weight of trying to get contact with the witnesses. He knows it. You know, this is a man who has given gallant service to this country in far remote bandit-prone regions. Until now, he's here. He has served this country with a lot of dedication. He is not afraid to be investigated. He's not afraid to be investigated. He stands innocent before this court and before the whole world. And according to his advocate, the manner in which the state has arraigned our client here is suspect. There are other extraneous reasons as captured, Your Honor, in this case. The last authority I will give you.
Sorry.
I'm only reading our authority.
Your Honor, before you read the authority, to share with us an affidavit just proving extraneous factors. Otherwise, he has done a very good job as client in response. He should see the ground so that we do the
I'm finishing with an authority.
All right.
Save that I didn't want to say that by virtue of the name he
You know,
carries.
you know, Mr. Omari would go and go. We object to the line that is going to those extraneous factors, including the line that council is taking with the suggestions of extraneous factors and political arguments. So he has done a good job on the law. The team has done a good job. I think he should not water it down with
In the High Court of Kenya at Mombasa, Judicial Review number 9 versus the Attorney General and the Commissioner of Police. Add to paragraph 8, and we have given a copy to the state, and we have given a copy to the court. On this floor, or so long as that law we are mentioning is in statute.
which has been brought through the window, is available or is an obligation of this court as suggested. It's something I've written on, so I can quote one decision on this. Understandably, the decision that Mr. Omari has referred to the court to, if I got him right, is a decision of number 96 of 2011, Your Honor? 93 of 2011. So he's my good friend. He may not have seen what Honorable Justice William Musyoka says in Dennis Rosana Manyibe.
Could you give us the authority?
I will give the citation. We didn't know you would raise the
we don't request. So, just give the citation.
Your Honor, Dennis Rosana Manyibe and 4 others versus ODPP and 2 others. The good judge is not only an authority in law of succession, he delivers a beauty of a judgment. The citation of this case is Kakamega Criminal Revision number E001 of 2022. E001 of 2022. And basically what the judge is doing is the nature of inquests in post-2010 Kenya. And I'll read one paragraph. This is what he says. I quote him, "The first is whether it was necessary," which is what Mr. Omari is telling you, "in the first place to conduct the inquiry in view of the letter by the first respondent, the ODPP. The purpose of conduct of inquest proceedings is to primarily determine the cause of death, particularly where it is suspected that the same was by hand of another. Where the persons responsible for the death are known, there would be no need to conduct an inquiry. The suspects ought to be arrested and arraigned to answer to a charge of either murder or manslaughter or any other related offense. The inquest would be conducted where there is doubt or where the causation is clouded in some mystery for the court to unravel the mystery. Where there is no mystery or the circumstances are fairly clear, then the first and second respondents need not ask the court to conduct an inquest." This is part of the law on inquest post-2010. There is a similar decision by J.B. Ojwang. He was a judge by the time. He rose all the way to the Supreme Court. And the decision which I would invite the court to have a look at is Nisha Sapra versus Republic. This is way before the Constitution of Kenya 2010, but it still has the same principle. There's also the decision of Honorable D.S. Majanja J. May the Lord God put his soul in eternal peace. In Re-Estate of Philip Otieno Odhiambo. Re-Estate of Philip Otieno Odhiambo. This is reported in 2015. And finally, on the question of inquests, one of my favorite judges, Justice Mwongo, my phone has just gone off, Your Honor, but I'll provide Justice Mwongo's decision.
Help us more knowledge. You know we are students. In those decisions,
bond of 7,000, release him on free bond. Your Honor, this court is bound by Section 60 of the Evidence Act, and this is 60, subsection 1, subsection O, to take judicial notice of matters of public notoriety. Judicial notice of matters of public notoriety. This court is human and does not live in vacuum. This court has eyes. You can see the number of media officers here. You can see the number of Kenyans in court today. This matter cannot be treated with a lack of seriousness. And what is the matter? The matter is that we are saying a Kenyan died in a Kenyan police station. And that Kenyan is identified as Albert Ojwang. You know, of course, we are both Luos, but that's not why I'm making this argument. That is a disclosure of conflict, possible conflict if there was. There is also admission from the defense that the person sitting as the respondent before you is the OCS. While they had questioned it in their affidavit, they have admitted severally. And not just the OCS. He's the OCS of, according to Mr. Cliff Ombeta, one of the greatest stations in Kenya. And that is not enough. According to Mr. Omari, he has been in the police service for 29 years. Now, with that point of reflection, just before I get to the decision of Titus Ngamao Musila Katitu, a police officer who has been in service for 29 years, who else would have more influence, either on witnesses and or the investigations? And with that point of reflection, allow me to just read paragraph 1, because the Court of Appeal, this is what the Court of Appeal says in the decision of Titus Ngamao Musila Katitu versus Republic. This decision is delivered on 24th April 2020 by Justice William Ouko, may rest in peace, Fatuma Sichale, and, sorry, William Ouko, I withdraw that, Fatuma Sichale and Ole Kantai. And this is what they say. This is why it is hurting me at this point. The blue code of silence, which we are being told not to talk about, is a common phenomenon spanning across different countries and police cultures in America, Europe, Asia, and even Africa. Kenya is part of Africa. You want to allow me to just read this. It is the unwritten rule according to which police officers never provide incriminating information about their colleagues, to close ranks in silence, and to cover up knowledge of a fellow officer's wrongdoing with a collective blanket of self-preservation. The offense we are talking about today is the offense of murder. There is no greater offense leading to self-preservation than the offense of murder. We admit that all offenses in Kenya are bailable, but there is no greater need for self-preservation where a police officer, no less than the officer commanding the station, is intended to be likely charged with the offense of murder. A feeling of esprit de corps among officers who by and large depend on each other for their very risky lives as they confront the violent and hostile world of policing and crime. This background is important, and I hope it is also important to us today in our consideration of this appeal, because the police in Kenya, as we shall demonstrate, the three judges are speaking, as we shall demonstrate in this case, as in others before it, has, in certain circumstances, engaged in the practice of covering up for each other. And the court proceeds to give examples. So that we are saying, when we say that the respondent before you is likely, in the act of self-preservation, interfere with ongoing investigations, we are not plucking it from the air. There is basis of it. The Court of Appeal has seen it before. Now let us go back to the... Yes, I hope the court will have an opportunity to look at the other parts. Let me go back to the application so that we get back the court to our application, because we may have lost what we are asking. And Mr. Kangai did a good job in referring you to the orders we are seeking. Your Honor, the limited order in prayer number B is that the respondent be remanded at the Langata police station or any other police station within the Republic of Kenya as the investigations may dictate, to enable the applicant conclude investigations. The main primary reason why we are asking to hold him is to enable the applicant, IPOA, complete investigations. Your Honor, now, there are very few questions which are necessary to contextualize. Is Albert Ojwang dead? Yes. Did he die in a police station? Yes. Was the police station Central Police Station in Nairobi? Yes. Is the respondent the officer in charge of that station at the material time? Yes. Has the IO informed you that investigations are ongoing? Yes. His affidavit evidence has not been contradicted or controverted. There is no denial that there are investigations. Coupled with the public interest, even as we presume the respondent innocent, would it be in the interest of the victim? We have seen, just like them from social media, the father of Albert Ojwang, confused, running across Nairobi. Is it in his interest as the victim and his family that the respondent should be released on 7,000 or free bond? Because the rights belong to who? Accused persons. And our answer is no. Your Honor, we are at an investigation stage. A decision may, most unlikely, but may still be made that the respondent in the dock is not to be charged. The decision to charge him or not has not been made. We are asking you, because of the complexity of the matter and because of the blue code of the police, which has been judicially noticed by the Court of Appeal of this country, allow us 21 days to complete investigations. If the investigations are complete before the 21 days, Mr. Jibril is a good man, except that he gets a little angered like me sometimes. If we complete these investigations before the 21 days, Mr. Jibril, you can confirm we can come back to court.
Yes, Your Honor, I do confirm.
We pray with you that approximation as per now is that 21 days will do justice not just to us, but also the respondent, so that we establish, as his advocates are suggesting, that he was not involved in this matter. As I conclude, Your Honor, there is a deliberate distinction by prioritization of Article 49(1)G and Article 49(1)H. I have always believed that when provisions of the law are put distinctly and separately, they mean different things. So that on the burden and standard of proof, Article 49(1)G, which requires at the first appearance that he be charged or informed of the reason for his detention or to be released, once we have given the reason, we have met the threshold. And that the arguments have been made, and that explains why most of the decisions that have been presented to you are decisions on bail pending trial. So that all we needed in of the bail and bond policy guidelines, the word likelihood is used at least 3 times. So that the likelihood to interfere with investigations is a sufficient ground, even if we were arguing bail pending trial, to deny bail. But on this lower threshold of a balance of probability, where we are asking you to let us complete investigations, the likelihood to interfere with investigations, as my brother will tell you, where there has been uncontroverted evidence of interference with CCTV, that likelihood is very high. And because of the blue code, please hold the respondent for at least 21 days. I submit and I humbly pray. Thank you very much.
This is the reason why I was highlighting earlier about some paragraphs. Let's look at paragraph 11 of the affidavit, where the respondent is alleged to have hired a technician to interfere with the CCTV system at Central Police Station. This is in a bid to tamper and interfere with the investigations. This is a compelling reason. Your 13D. Yes. That the respondent, together with other persons at Central Police Station, are suspected to have caused to be made false entries in the police records, of course with a view of misleading the investigations. Again, paragraph 17. that the CCTV surveillance system installed at the respondent's office, had been interfered with the DVR power cable disconnected, and the DVR logs indicated that the operating disks had been changed and formatted. And we have gone further. That is on the 8th June 2025 at 7:28:43 hours and 7:32:29 hours. Your Honor, paragraph 18, still on the tampering of the CCTV. Paragraph 20 and 23 on the issue of interference with the police officers. These are compelling reasons. With that said, Your Honor, we still request and we urge you that you grant us the 21 days, which will be sufficient to complete the investigation. That is all from the prosecution.
Adopting whatever the law states to what the facts are. So I want to thank you for that. I propose we come back on Wednesday at 2 p.m. for a ruling. So in the meantime, I'm not sure, can the respondent still be detained remanded at the Langata? Yes, sir. PM on the 18th of June, on Wednesday.
And I appear alongside my learned seniors. You all know Senior Omari, Senior Cleveland Beta, and all other attorneys at law. We have had a fruitful session today before the court of law. Reasons being, you've seen what has been going rounds. But now it was our day today, to put on record all these issues surrounding the death of Albert Ojwang, and also to demonstrate that our client is not criminally culpable in any way. We've done our part. We've interrogated and confronted the evidence that were tendered by the Independent Policing Oversight Authority. The court has had a chance of hearing us and also hearing the side of the prosecution. And as we all know, ruling will be rendered on Wednesday, and we await the court's finding or determination on that. Of course, this was also a good day because from the legal perspective, many issues have arose. You've all seen the gray areas in law which needs to be illuminated by the court. And we hope also that ruling also, apart from settling the issues in controversy, will also be able to illuminate certain aspects of law for the benefit and also for our betterment of our jurisprudence. So from my side, I beg to rest. I will invite in my seniors.
Or we, as the team, that he has been interdicted and has been asked to be reporting every week at Eldoret Police Station. Even with that in mind,
the state, through IPOA, has decided that they want to bring him to court and hold him for investigation. This is a man who they are saying probably would want to abscond, probably would want to interfere with witnesses. They are forgetting one thing, that all along he has been outside. If he wanted to interfere, he would have done that from before. He did not do that. If he wanted to abscond, he had a free ticket, he would have gone. He did not do that. Why? Being a straightforward person, and a person of integrity, and a person of his standing, and a person who has a family, who sympathizes with this situation, he'd want to clear his name. He wouldn't want to go out in disgrace. And I said this before. All they needed to do is ask him, come, let us record your statement, come, let us do this. And when you charge him, then you interdict him. But because of the hula baloo that is going on, because of the interest out there, what does IPOA and the other officers want to do? They come into a public relations exercise. To do what? To clean their names. Look for somebody who can be blamed. To look for somebody who was never there, who was far off from the scene, who was never anywhere near at that particular place. And they say he wants to interfere with the CCTVs and such kind of a thing, when already IPOA had already taken over the scene before he arrived there. A public relations exercise. And I said it before. Who is going to be the fall guy? When I saw how it was going, I said the OCS would be the fall guy. Isn't it coming to pass? Instead of us playing this public relations exercise, let us go to the nitty-gritty of the case. Let us find out the details. Let us do the investigation. And in all this, as we do it, let us be fair. Let us use all this that we call the fundamental rights and everything. They are there for a reason. They are there to protect such kind of victims and other persons. Let us not play public relations.
For the loss of Ojwan'G, the defense team here passes condolences to that family. The defense here is just discharging its mandate under the cab-rank rule that we have got to defend everybody who comes to us. Albert Talam passes condolences to the family of Ojwang. But after that, several key points need to come to the public. One, Mr. Talam was never arrested in Eldoret, where he comes from. His lawyer, Kito, presented him to the DCI, and the DCI took him to IPOA, where he recorded a statement. Number two, Mr. Talam had handed over the station to his deputy and handed over all the instruments of an OCS, which is the office, the pocket phone and everything, when this occurrence happened. And we shall be raising a defense of alibi. Third, IPOA has confirmed that the deceased died in a police cell. The law of anybody who dies in a police cell is in section 385, 386, 387, and 388 of the Criminal Procedure Code. An inquest happens. We have gone to the High Court, filed a constitutional petition before the judge that the arraignment of the OCS is actuated by other exterior issues. The political class, civil society, and very many other actors are being blood for the DIG, who equally comes from Eldoret. And that is why we are very clear that let not Talam be sacrificed just because of his ethnicity. For record purposes, the DIG reported an offense, an allegation. Communication between the DIG to an OCS does not exist. The chain of command of the DIG is to give directions. If at all, he'll give directions to the operations director. That information will be relayed to the regional commanders. The regional commanders will relay the information to the county commanders. The county commanders will relay information to the OSPD. Then from the OSPD to the OCS. Let us not move in the manner we are moving, because this, bringing Mr. Talam here, is mob lynching. IPOA is reacting to what the public, and that public is not representative enough. Due process must be followed. An inquest must be put in place so that the country knows what is there. The police cell called Central, the media will not be allowed to be there. From entry, you get a report office where the sentry, who has the key, is. There were two. From there, where they were, to the entry, the gate going to the cells is more than 15 meters. Then that is the only door that one can access the cells. Then after you get inside, you get a holding area where when advocates go, they take instructions from their clients and such things. Then there's a corridor, and in that corridor, on the left-hand side, there are 3 cells. The first cell belongs to women. It is lockable. The second cell belongs to the children. It is lockable. The third cell, the last cell on the other side, it belongs to men. It is not lockable. It is a cubicle. On the right-hand side, there are also 3 other male cells. They are not lockable. If one is in cube 1, he has access to cube 2, he has access to cube 3, he has access to the opposite cell. And that IPOA is not telling the country. It is not true that the deceased was in a cell to himself that was locked. Then the last part is the ablution. The distance from the last cell to the officers at the report office is more than 100 meters. Inside the cell, there were inmates. The police called them prisoners. And anybody who has gone to Central Police Station will agree that there's a lot of noise. Those who are drunk and disorderly are arrested. People are making a lot of noise. It is a mess of a market. Expecting the OCS to know what has happened. It is not the first time a prisoner has died in police cell. Yesterday, one died at Homa Bay. It is common. All the inmates are criminals, suspects of serious offenses. No policeman is allowed to be with them in the cells. And that is why we are telling IPOA that this matter can only be resolved by an inquest where the magistrate lives here, members of the Fourth Estate are allowed to access the cells, and the interrogation is conducted where everybody will give his explanation, and the recommendation goes to the DPP. If the DPP finds somebody culpable, that person is the one to be arrested, and the DPP approves the charges. We know very well the commissioners in IPOA are greenhorns. They came to the office 2 months ago. They might not be knowing the right procedures to follow. Ojwang was killed illegally. They cannot also process Talam and the others illegally. Due process must be followed. The due process we are demanding as the defense is that let them follow what is prescribed by law. Those being the circumstances, the defense is determined to push this agenda and to defend whoever is being dragged to this court. We are aware political parties have filed petitions for the removal of the DIG. We sense, and we are very certain, politics is in this matter. We are not politicians. Until I become the senator, for now I'm not a politician, but as a defense team, we will demand the proper interpretation of the law and justice to be done to Ojwang. IPOA has confirmed 3 civilians have been arrested. Stepped down because I'm not the government spokesperson. The media can follow who has stepped down. But as we are putting this thing in order, the position is very clear that Lagat has nothing to do. Not Lagat. Talam has nothing to do with this matter. Thank you very much.